Welcome our speakers, our guest speakers particularly, those not on UNSW staff, but also all of you in the audience, to the faculty, to this special forum on doping in sport. So it's great to see you here. How we're going to run the event is we've got so much expertise. Really what we want to have is for them to be able to get up and start talking about the topic without someone like me getting up and interrupting the flow of the ideas for you in the audience by giving a description as to who they are and what their specialty is. So I'm going to introduce all of the speakers now in the order in which they'll be speaking and give a very small indication as to what aspect of this topic they'll be talking about. And I'll also introduce our moderator, Tracey Holmes. And then the speakers are just going to go for it. Okay? And they've got 10 minutes each, and they're going to talk about their view on this topic. And then Tracey's going to kick off the discussion, and hopefully you will be contributors to that when they're sort of sitting in the round as well. So that's the format. And now turning to our expert panel, in the order in which they are sitting as well as speaking. To my immediate left is Catherine Ordway, who's an international sports doping consultant. And she's got over 15 years' experience in sports law and anti-doping internationally, and developed her expertise in this area whilst advising the Australian Olympic Committee in the lead up to Sydney 2000 Games, when she prosecuted approximately 1/3 of the world's anti-doping cases before the Court of Arbitration for Sport. She has since worked in the Anti-Doping and Ethics Department of the Norwegian Olympic Committee, drafted the World Anti-Doping Agency, or WADA, model rules for national anti-doping organisations. She became the head of doping control at the Doha Asian Games Organising Committee in Qatar and assisted in the establishment of the Qatar National Anti-Doping Committee. She was formerly Group Director Enforcement with the newly established Australian Sports Anti-Doping Authority, ASADA, as well as being involved in a number of anti-doping tribunals. And it's great to have Catherine up from Canberra to be with us tonight. She's going to be talking about these issues in relation to governance of sport. Beside Catherine is Professor Andrew Byrnes, Professor of International Law in the faculty here, who joined us in May of 2005. Andrew is currently Chair of the Steering Committee of the Australian Centre for Human Rights, and since November of 2012 he has occupied the post of External Legal Advisor to the Australian Parliamentary Joint Committee on Human Rights, and unsurprisingly he's going to talk about doping in sport from a human rights perspective. Plumb in the middle is Dr. Tom Hickie, who's a member of the bars of both New South Wales and England and Wales, and he's practiced in a number of areas of the bar, including obviously sports law, and is the course coordinator of Sport and the Law at UNSW, has been for over a decade. And in 2005 he won the Vice-Chancellor's Sessional Teaching Award for the excellence of his teaching in that course. Dr. Hickie is a past board member of the Lloyd McDermott Aboriginal Development Team, seeking to give talented Indigenous youth a future through education and sport. He's a life member of the Australian Society for Sports History, a member of the British Association for Sport Law, and a member of the Australian and New Zealand Sports Law Association, and has, not surprisingly, written widely on sport and law and sport and history. And he's going to be talking about athletes' rights in the controversy over doping in sports. Beside Tom is Professor Prue, who's a late addition to the program, given the inability of John Marshall to join us, a late sort of scratching, and Prue has stepped up in a very characteristic fashion without any qualm or fuss and said, I can talk about this. Her major areas of research are torts, especially apologies in civil liability, and succession law. And she's the co-director of the Private Law Research and Policy Group at UNSW and a visiting professor at Strathclyde University Law School in Glasgow, Scotland. And she's going to be talking about tort liability in doping situations. And then at the very end is the driving force and mastermind behind the whole event, Associate Professor Deborah Healey, who I'm sure many of you know. Deb has practiced, taught and written about sport and law for many years. She's the author of Australia's leading textbook, Sport and Law, which has been continuously in print for 23 years. And she teaches courses in the Masters here, such as Sports Sponsorship and Marketing. She's been a member of the Australian and New Zealand Sports Law Association since its inception. She edits the Australian and New Zealand sports law journals. She's been a board member of a number of sports, regularly sits as a member of a variety of sporting tribunals, and has represented individuals and sports in the Court of Arbitration for Sport. She implemented the WADA code for a major Australian code. Deborah is a regular media commentator on sports and law issues. And she'll be talking about issues relating to sport organisations, governance, and the regulatory framework around doping. Lastly, but very crucially, is our moderator for this evening, Tracey Holmes, who is a well-known Australian television and radio presenter specialising largely in sport. And she began working as a journalist for the ABC in 1989 and was Australia's first female host of a national sports program, Grandstand. From 96 to 98, she was a media advisor for SOCOG, the Sydney Organising Committee for the Olympic Games. And from 98 to 2000, she worked as a sports presenter for Channel 7 before heading overseas to work in sports broadcasting in Beijing and Hong Kong, to which she returned after a stint in Sydney, the end of the noughties, where she once again joined Grandstand, and after having been back on CCTV as a news anchor in China, that's China's English language news channel, Tracey has returned to Sydney in the last couple of months, so it's great to have her here for an event like this. So that's the lineup, and I'll pass over now straight away to Catherine, who's going to, I will resist saying kick us off. Start us off. Thanks, Catherine.
Thank you very much, Andrew, and thank you, Deborah, for asking me to be here tonight. It's a great pleasure to be back in Sydney. As Andrew mentioned, my anti-doping career kicked off here. I got to use kicked off in the lead up to the Sydney Games. And that was a very daunting prospect. At that time, I knew nothing at all about anti-doping back in '97, and I was asked to draft all the anti-doping policies for the national sporting organisations in preparation for the Sydney Olympics. Because, of course, at that time, we were hosting and we wanted to present a good face to the rest of the world, and we wanted to be able to point fingers to everybody else and say, our backyard's cleaned up, so you better get yours cleaned up too, so that we're all playing on a level playing field. Of course, our backyard wasn't anywhere near cleaned up at that time, and neither was anyone else's, because that predated the World Anti-Doping Agency at all, which didn't come into existence until '99. And we didn't have our first code until 2003. So before that, there was certainly a lot of work being done in the initial stages in anti-doping from the 1960s onwards. And the International Olympic Committee developed what was known as the OMADC, the Olympic Movement Anti-Doping Code. But each of the international federations pretty much saw that as merely a guide. So they did their own thing. What the Australian Olympic Committee did, though, was to say, we want to make sure that every Australian athlete is treated exactly the same. No matter whether you're a tennis player or a canoeist or a rugby league player, we want you all to be treated the same. And what was groundbreaking at that time is that the Australian Sports Commission and the AOC were able to work together to make one anti-doping template, one anti-doping policy for all sports in Australia. So that was a huge thing for us. At that time, people older than me will remember better that the AOC and the ASC didn't necessarily get along terribly well. So that was a good thing to come together for the anti-doping cause. That caused a few little glitches. You can imagine that some sports, and tennis was one of them, that said, well, we don't care what's happening in Australia. We want all of our athletes, tennis players, for example, treated the same no matter where they come from. So you can say what you like, Australia, but we want to do what we want to do for tennis players. So that caused a bit of a rift, and we had to work through those issues. And as Andrew mentioned, I also prosecuted all of the cases before the Court of Arbitration for Sport on behalf of the AOC. Because back at that time, there was no ASADA. ASADA didn't come into being until 2006, but we had its precursor in place, and that was ASDA, the Australian Sports Drug Agency. And the Australian Sports Drug Agency didn't have any enforcement and prosecution powers, so it was left all to the sports to do. So you'll know from your experience with national sporting organisations now, it's no different then, that some of them are kind of mum and dad around the kitchen table organisations, and some are multi-million-dollar, highly resourced organisations. So some of them are working very well to organise their anti-doping work under their anti-doping policies, and some were pretty much putting it in the bottom drawer in the too hard basket. So what was great about the AOC initiative is that they got one consistent approach in doing the prosecutions to make sure that we didn't have the risk of the star player being put to one side and not being addressed. Because that's the danger, of course. If you've got the sports doing the prosecutions, they both want to see a good outcome for their sponsors and for their participants, and they also want to uphold the anti-doping side. So it's a bit fox and hen house, if you know that expression. So the best thing about the new Act, under the ASADA Act, is that we took that in-house. We have an independent, I use that advisedly, an independent agency doing the prosecutions and the enforcement work. And WADA, on the other side, came into being with its 2003 code, as I mentioned, and you'll probably have seen some of the information in the paper because the president of WADA now is an Australian, in John Fay, that a new code is being reviewed at the moment. So it goes through iterations and consultation over time. The 2003 code was a first stab at it, and all the sports got on board and wanted to do something collectively as an international sporting community, and that was fantastic. Then that got some changes through to 2009, and now we've been going through a 12-month process of a consultation in order to develop a new code which will come into effect on the 1st of January 2015. That's about to be voted on in South Africa in November. So that's the big picture of where we're at in terms of framework. In the absence of John Marshall, I just wanted to bring up one issue that is still causing concern under the code. There's been some really fantastic developments in anti-doping in the time that I've been involved, not least of which, as I mentioned, is bodies like ASADA and other national anti-doping organisations do the prosecutions and enforcements work themselves rather than leaving it to the sports to do. But one area that is still a bit of an anomaly is in relation to team sports. Because the code was first established out of the OMADC, I mentioned the International Olympic Committee, Olympic Movement Anti-Doping Code, WADA's jointly funded by the sports industry, by the IOC primarily, but also the international federations on one side, and by the governments on the other side. So what that means is that there's a very strong Olympic movement emphasis in the code, and it doesn't properly reflect, in my view, the professional sports that we see in Australia, particularly professional men's football codes, and yet it's a one-size-fits-all kind of model under the code. In order to get standardisation and harmonisation that's so important as compared with what we had before where every sport was doing its own thing, the downside to that is that you've got some really inequitable situations coming up. So one of those quite clearly is potentially coming up for us with ASADA going to hand down its final report any day now, potentially, depending on which media report you read. Under the WADA code, it's been established in order to deal really with the Olympic situation with team sports. And so if you have a doping case where 3 people go positive in an Olympic Games, they know how to deal with that. Even if it's outside of the Olympic Games, if it's that kind of a structure where it's a national team playing a national team, the Olympic Code can deal with that pretty much. I'll give you a scenario where it didn't really work, but it's really set up for that. What it's not set up for is how to deal with a week in, week out playing situation. So the issue that we have at the moment in the AFL and the NRL context is that we've got the week in, week out playing, but the sanctions that are potentially going to be attracted by the athletes and the coaches is a 2-year sanction. So how does that impact Essendon potentially? If Essendon goes down for an anti-doping rule violation, the club, the players, however it's structured, worst case scenario, then what does that mean? Does that mean that Essendon is out of the AFL competition for 2 years? Where does that leave the AFL? Where does it leave the club, the players, the sponsors? It just hasn't been thought through. And even though we were given consultation rights and an opportunity to respond to the code, I don't think that the code drafters have really thought through how they can deal with this day-to-day, week-in, week-out playing scenario. I'll give you an example for how they do it in the Olympic setting that didn't really work very well either, and that was in football, soccer football, FIFA setting. In the lead up to the London Games, I was asked by the FFA to have a look at the Matildas situation. The Matildas, perhaps you would recognise if you follow them, didn't play at the London Olympics, and that was because they were knocked out by North Korea. And North Korea played at the World Championships a little bit prior to the Asian qualifiers, and 5 of their players went positive at the World Championships in Germany. And 5 of their players went positive because they had apparently been administered deer musk for a treatment that they said resulted out of a lightning strike to all the players. So lightning strike resulted in 19 steroids apparently being found in this deer musk, and 5 of the players going positive. So they were knocked out, that's fine. But because FIFA's only interested in protecting their own brand and the WADA code allows the sport to do the team sanction, that team has been banned for the following World Cup, which is in 2015 in Canada, so North Korea won't be appearing there. But football doesn't care at all about that little event that was in between, namely the London Olympic Games. So North Korea was allowed to appear at the Asian qualifiers and knocked out the Matildas. Very inequitable situation, and one that I think really needs to be addressed in the WADA code. But clearly it's not going to happen for 2015 because the voting's in November, but I'm hoping that enough people will understand over time that team sports are really not being addressed properly under the code and they need to be in the next round.
Thanks very much, Catherine. Raises plenty of issues which we'll get to talk to after we hear from each of the panellists, and hopefully you're taking notes as well so that the engagement works 2 ways, not just 1 way. Okay, so our next speaker, Professor Andrew Byrnes, as you heard, from the Faculty of Law and the Australian Centre for Human Rights, which will take us on a completely different tack, I think.
Okay, thanks very much, Tracey. Yes, you're going to get the reflections of a human rights lawyer with no particular expertise in the field of anti-doping law or sports law. I'm probably where Catherine was 15 years ago, that is, but I know a little bit about human rights, and perhaps less about sport. Perhaps my only previous contact with the anti-doping regime has been in my role as external legal advisor to the Parliamentary Joint Committee, which looked earlier this year at the amendments to the USADA legislation, which raised some interesting issues. So these are some general comments which are going to raise questions as much as provide answers, partly because I don't know the area deeply enough to be sure that the questions can be turned into definitive statements. But I think it's true to say that while anti-doping law has its distinct developments, it's also one example of a much broader pattern of ever-expanding, ever more detailed and intrusive regulatory schemes, both within and outside government. And many of these are creeping processes, and it's useful, I think, to stop and step back from some of them occasionally to see whether the purported benefits, the actual benefits, have lived up to the claimed or the hoped for benefits, but also some of the costs. Certainly my impression from a fairly quick review during an overseas trip recently is that, as with many areas, the desire to eradicate an insidious practice may sometimes lead to tunnel vision in this area as in others, or at least too great a readiness to accept particular methods as proportionate to the achievement of legitimate goals, and to overestimate causal relations between means chosen and the desired outcomes. I'm going to divide my comments into three areas. Firstly, some general comments about human rights and the regulatory regime in the anti-doping field. Secondly, some comments on human rights aspects of the USADA 2013 amendments, which illustrate some of the broader issues. Then thirdly, a few examples which I came across in reading some of the literature, which struck me as rather odd and raised the concerns that I had about issues of proportionality that are at the fundamental to human rights issues. Firstly, the relevance of human rights to the area of regulation through anti-doping. Traditionally, of course, human rights have been about the obligations of the state to act or refrain from acting in a particular way, and normally then is required a fairly direct nexus between state action and adverse impact on an individual's way of conducting him or herself. But sports regulation and doping procedures originally and are still fundamentally in many ways embodied in private legal relations in the form essentially of contractual arrangements through individual sporting organisations and sportsmen and women, underpinned by agreements for binding arbitration that fall under the umbrella of arbitration-friendly laws of states that provide for minimal review of the informal non-state processes of dispute resolution and adjudication on the various claims that come up, including anti-doping prosecutions. So what we have is adjudication by national or international sporting bodies and their particular dispute procedures with, in many cases, review or appeal to appellate bodies, in particular the one mentioned by Catherine, the Court of Arbitration for Sport, which is subject to some but minimal review by the Swiss Federal Supreme Court. Thus, to the extent that formal human rights principles are relevant, they're not actually incorporated formally, not being binding on private associations, but nonetheless, of course, there are many similar guarantees that appear in the common law and other general law relating to the way in which professional bodies and associations conduct themselves. The classic common law principles of procedural fairness where disadvantages are being imposed on members of organisations. But what this does, and I'll speak a little bit about the extent to which, notwithstanding this private model, human rights principles have in fact been taken up fairly energetically within at least the wider framework. It does raise the issue, which is critical to the contractual arrangement model of consent. And one of the critical issues in relation to the fairly wide-ranging and intrusive measures of testing that form part of the wider code and the subsidiary national codes is the extent to which the consent of the players, the consent of those who are involved in the sports, in a way legitimates or waives rights that they might otherwise be entitled to. What is the significance of consent? Is the consent real? How do we make that assessment? It's problematic in the context of consent to state incursions on rights. It's also even more problematic with private ones. Thirdly, of course, that's an idealised view, and the state has become involved, as we heard from Catherine's description. We now have ASADA, we've had previous agencies. States become involved, whether under their own individual schemes, under which doping may itself be a violation of freestanding criminal law, or their regulatory or funding models. In Australia, I think funding from the federal government to sports is made conditional upon compliance with the wider code. So there are ways in which government becomes implicated in and responsible for driving particular approaches. And added to this is the UNESCO Anti-Doping Convention, under which states, including Australia, have agreed to give effect to and support the implementation of the wider code in their jurisdictions. Some striking features, though, I think, of the way in which things have developed in the wider code. There's been, I think, a very evident effort to try and introduce human rights values into the provisions of the code and the administration of the code. It's been very focused on European Convention on Human Rights standards, so a great focus on civil and political rights, less on relevant economic, social and cultural rights, and been reasonably comparative in approach, although I suppose with a greater focus on civil law, European analytical frameworks. But the important framework which has been endorsed, and the one I think which gives rise to problems in practice, is the framework of what is a permissible limitation. Much of the regulatory activity in the field involves infringement or encroachments, limitations on the enjoyment of human rights. And in order to justify these in human rights terms, there's a fairly well-established framework, as I've said. Any restrictions must be in pursuit of a legitimate objective, normally not a problem. Level playing field, health of players, and the various other objectives which are rehearsed in this context, I think, are legitimate objectives. Must have a rational connection to the achievement of that objective. That is, it must be likely to contribute to bringing it about. somewhat more problematic, I think. And it must be a proportionate measure, reasonable, not over-inclusive. There must be consideration of whether there are less restrictive ways of achieving the goal, and there must be provision to ensure against abuse. And the onus is on the person proposing the restriction, and generally there's a requirement for some evidentiary base. Assertion is not enough. And I'll come back to that because I think there are some issues, at least questions, perhaps not issues, around some of the measures that have been adopted. Let me illustrate with the ASADA legislation through the 2013 amendments. They introduced a new part to the Act involving and reinforcing a power on the part of the Chief Executive Officer of ASADA to order disclosure of information, documents and materials where the CEO believed that the person may have material that was relevant to a doping investigation. A whole range of issues came up because they drew on a regulatory framework, a responsive regulation framework, which makes very heavy use of this concept, this device of civil penalties, which look very much like criminal penalties, but they're called civil and they're implemented on a lesser standard of proof. It's a whole range of issues, and this is an illustration, I think, of a regulatory scheme which does that, which has appeared right across the Commonwealth Government in particular. So there were concerns about that and whether the compulsory power and the use of information in subsequent proceedings would be fair and consistent with human rights principles. Self-incrimination issues came up as well, and in particular the power to compel disclosure from family members, for example, was seen as quite unproblematic by the proponents of the legislation. So the issues are dealt with in some length in the Parliamentary Joint Committee on Human Rights reports on the issue, but it seemed to me that there was, what they illustrate in terms of the way it was put forward was a notion that these were really unproblematic, that if the goal was legitimate, then questions of proportionality really fell by the wayside. So a couple of questions then to conclude. The question of rational connection, the analytical framework for limitations that I outlined earlier, and the tendency to make assumptions that if something looks as if it might work, intuitively might contribute to a goal, that it is therefore legitimate, I think is something that one has to be a little careful of. There's a great deal of emphasis in the lengthy legal opinions published by WADA in relation to the various revisions of the code about the severity of sanctions, a 2-year sanction, 4-year sanction, a life ban after three infractions, as a deterrent. And I think anyone who's done anything in criminology knows that it's not the heaviness, the severity of the sanction which is necessarily determinative of the deterrent effect, but it's the likelihood of getting caught. And that seems, just reading through some of that material, not to be taken into account. Proportionality, I've mentioned, the question of a whereabouts regime. Athletes who are subject to the whereabouts regime have to inform the authorities for 3 months in advance where they'll be all the time and nominate an hour a day when they will be available for testing. They can be tested at any time. Ranges of issues as to whether that's a proportionate measure applied across the variety of types of sports. There's a learned debate in one of the most recent opinions on the 2015 code as to whether it should be permissible to be able to arrive unannounced to test people up to 9 o'clock at night or up to 11 o'clock at night and from 6 o'clock in the morning. You can go in between 11 and 6 if you've got serious grounds for believing they're engaging in doping. So there are real issues, I think, about proportionality there, though the goal, I think, is fairly clear. And finally, let me just give you one example of I came across a rather unfortunate Irish kickboxer by the name of Julie McHale, who'd just got a new job with a firm and was about to head off to try and land an important client from her old firm, but a couple of doping officers, she was an amateur, a couple of doping officers turned up and wanted to get a urine test from her, I think it was. She said, look, I'm dashing out the door, I've got to go there, I've got to land this client, it's important, I don't want to be late, it's a new job, this is really important, I've got to go. And she refused. And they said, oh, look, it's okay, look, we'll come along with you and we'll sit with you in the meeting and we'll be there and so on. She said, no, look, get real. At the end of the day, she was found guilty, she was found not to have justification, and the Irish appeal panel concluded and said, look, we have sympathy for the predicament in which Ms. McHale found herself, For amateur athletes, the necessity to earn a living and the demands of one's work can clearly create significant conflicts with the requirements of the sport in which one chooses to participate. But we find it difficult to see how it can be said that Ms McHale bore no fault or negligence. It's undoubtedly the case she was only a short time in her new job, that the appointment with a potentially important customer had apparently taken quite some time to arrange, and it was clearly important to her that she make the meeting on time. We can also understand why she was reluctant to have the officials sit in on the meeting to keep her under observation until she could give a sample. That sympathy didn't go far enough. She got 2 years, there was no reduction in it, and so maybe entirely justified. I'm not a doping lawyer. It seems to me, though, it does raise issues about the proportionality of human rights. It's critical to human rights assessment, and that looking at some of the ever-creeping regulation, that it may be appropriate to step back and revisit some of those issues again.
I think you're right, Professor. It raises so many more questions than there are answers. And I know there's actually a syndrome now that they can test for that a lot of athletes suffer, particularly female athletes, because of the method of testing. And they get tested, especially, you know, some of the very elite athletes that consistently do well or win. They're tested again and again and again. And they develop these stress factors because to be tested as a female is pretty horrendous, because you've got 1 or 2 testers very close, very personal, observing everything, even to the point where at the moment, well actually after the London Olympics, there were some female athletes who were reported on by the testers who informed the international sporting organisations that these women didn't look like some other women they tested. They didn't look like men, but their genitalia was different. And they actually had to go to a hospital in France where they went through this really terrible testing and were advised that they needed operations if they wanted to continue competing in the elite level of sport. All of these women were African, who had very little support or understanding of how things were going, and this is kind of when you don't have someone looking after the human rights or the athlete welfare, and it's only sort of top heavy, there's a lot of questions, as you say. All right, let's move on. Our next speaker is one of Australia's foremost minds in sport and the law. Please welcome him, Dr. Tom Hickie.
What makes a king out of a slave? Courage. What makes the flag on the mast to wave? Courage. What makes the elephant charge his tusk and the misty misk and the musky musk? Courage. What makes the muskrat guard his musk? Courage. What makes the sphinx the seventh wonder? Courage. What makes the dawn come up like thunder? Courage. What makes the hot nut so hot? What put the ape in apricot? What's he got that I ain't got? Courage. Ah, that great 1939 film, The Wizard of Oz, teaches so much children's stories. Most lawyers, I say, are not like the Scarecrow. We are so sanctimonious and so self-important, we don't identify with the Scarecrow. Normally it would be the Tim Woodsman who needs a heart, perhaps, or I always think the Cowardly Lion, who needs courage to take on injustice, because often the myth is that all the lawyers are out there going to take on injustice. Well, I have to say, when Deb gave me this brief, my brief is to talk about the Waiter Code and the rights of athletes. And I found when I was at the bar in the UK, it was easy. It was the first time in my life I had to prosecute. Much easier prosecuting than defending. Anyhow, Deb, I promised I'll do 10 minutes for you. So as in terms of turning to the code, the greatest thing, and if we had the PowerPoint here tonight, I'd put up for you, is the slogan, play true. Now, the preamble to the code has the fundamental rationale is to preserve what is intrinsically valuable about sport. It is the essence of Olympism. It is how we play true. And I went through this code and I was talking to Deb about it, and I looked through the definitions, the appendices. I couldn't understand what play true or Olympism is, but it's there, and that's what underpins it. So I harked back and I thought, soon I've got to put the other side of the defence here, is in terms of looking at Canadian academic Emeritus Professor Helen Jefferson-Lenski, who's a bit out there, who's criticised the IOC. And she's criticised what these fuzzy concepts, the Olympic family, the Olympic spirit, Olympism. And she said it's somewhat pseudo-religious, and you start wondering. And she questioned, more of the media, more of government need to question these things. What are we talking about? And I'm glad we've heard with the first two speakers tonight, there are some problems with the code. There are some problems that need to be thought about and balanced. Also, I think in terms of the concern that was passed in the dying days of the Gillard government, that last week of June, where with the support of supposedly human rights, that group, the Greens, the legislation went through. Now, interestingly, in the lobbying held in Sydney Opera House last week with Ann Summers and the former Prime Minister Julia Gillard, not one question got asked. A hard question, I thought, about how did this happen? That final week, how did this legislation get... We're talking about sport. We're talking about sport. And in terms of the powers that Andrew was just talking about, it is a concern for all of us. And I think none of this has been talked about in the media, but we're going to hear more, I think, as our first two speakers have highlighted. Anyhow, is in terms of the actual code, the other concern that I've had is in terms of if we step back, the code's had its own problems. If we look at the Sydney 2000 Olympics, if we want to look at the example of an absolute sham, a sham, this code is, was the 16-year-old Romanian gymnast, Andrei Radican, who was given a cold tablet by her physician. Remember when you were all 16? Take a tablet. That's in terms of, the problem was what it contained. Everyone admitted it went to the Court of Arbitration for Sport, who I have to explain is not a court. They're just arbitrators, barristers and lawyers and others for sport, who it went to them and they said, well, look, a bit like the example Professor has just given you. They said, look, yes, she's innocent, but we can't do anything about it. Stripped of her gold medal. Now, surely there was a problem there. And in terms of the representative from CAS explained, it's what we call strict liability. But it's not actually strict liability. As we understand as lawyers, in places like Australia and Canada and others, we have mens rea, we have a guilty mind, we have, in terms of strict liability, that you've done on its face, it looks like, but you have an honest and reasonable mistake, and you have absolute liability and only goes to penalty in terms of mitigation. But the code talks about strict liability, which people often get concerned about. It took, however, that great Olympus, probably one of the great Olympians of the 20th century, Nada Comaneci. Some of us are old enough to remember the 1976 Olympics, she scored the perfect 10. And she was at the Sydney 2000 Olympics and she said this, I understand when somebody takes something to enhance their performance, it's one thing. And I understand this Olympics, the Sydney 2000 Olympics, are the Olympics with a kind of zero tolerance, as they say, for people who test positive. But I think not every case is the same, and not every sport is the same. I didn't understand why the decision was made in such a way, and it's difficult for me to explain to Radican in my own language. You're innocent, but we're still going to take the medal from you. I don't think that's fair. It took Nada Comaneci from Romania, a non-common law country, to explain in simple terms for all of us, would have been obvious to all of us in Sydney here, Australia, that not every case is the same, and there should not be absolute liability. Interesting, that system as well. As we know, places like Australia, Canada have dealt with this through the 1970s and 80s. There were a number of important decisions in the High Court of Australia and the Supreme Court of Canada looking at this in drug importation cases. I was saying there must be the penalties. We must look at this question, whether there should be mens rea, strict liability with an honest and reasonable mistake, and absolute liability. However, you would think with that background, the concern is, when I looked up who sits on the WADA code, and we heard earlier from Catherine, yes, it is an Australian who's the president, a former lawyer. The foundation president is a Canadian lawyer, is in terms of the director, is a New Zealand lawyer, and is in terms of the current president of the International Council of the Arbitration for Sport, is another Australian lawyer. You think they learnt this stuff at law school? I don't know. It's in terms of through, and you think about those issues. I do understand the other side of the argument saying because it's doping, it's so serious. But even in horse racing, the horse gets another go. And I think about these things. And I think we need to think about the legislation. Maybe if we're going to have this hard, then it needs to be legislation set up like a racing tribunal, doing it properly, I think as Catherine was talking about earlier, for the professional sports where there's gambling. But when I'm running around on the university oval in the afternoon, does anyone care if I've had a beer or a hot one or what's going on? I mean, this is what we need to think about in terms of athletes and their rights, and are we going to try and get young people to play sport? In terms of the Court of Arbitration for Sport, as I said, it is a misnomer. And the problem is, it's not a court of law. If I've got a problem, what can they do? They can't overturn. They've got to look at what was the agreement, and quite rightly, as I said, there's a contract there. I've signed it. I've agreed. That was the problem for Ruddikin. What could they do? These are things we need to think about, like as they have in horse racing, where they do have a racing tribunal, and you can go to a judge, a real judge, and perhaps get some real law. The concern is in terms of, we've also had the decision of Raguse and Sullivan, which was at the time of the Sydney Olympics, which was a selection dispute. And unfortunately, the New South Wales Court of Appeal said, you've signed an arbitration agreement, you can't appeal to us. You've signed that Court of Arbitration for Sport, it's arbitration, and in fact, if you really want to appeal, guess where you've got to go? Lausanne, Switzerland. Now think about this. This is a sport, two judo people playing in Sydney, Australia, and where they go, Lausanne, Switzerland. Something doesn't make sense here. The other issue is in terms of concerns, in terms of appeals then. Where are we going with all this? Because the other issue is, as this legislation that's now been passed in the middle of this year, and as I said, we'll see how it plays out. The concern being is in terms of draconian powers have been given to the CEO of ASADA. These are powers that normally, in terms of as a criminal lawyer, police, right, the Australian Crime Commission, any of these people would actually have to go before a judge to get a warrant to go into someone's house at 6 o'clock in the morning. How has this happened? Thank you, the Greens. In terms of with this. As well is in terms of, in light of the Ruddikin case and in light of all this, if promoting fair play is the basis of the code, is it not ironic that the whole code is so unfair? I mean, play true. Is in terms of as well, what about drugs in sport, in terms of recreational drugs? Somehow that got into the code, I don't know why, but they've now seen WADA see themselves as part of national law enforcement to do with illicit drugs. What are they going to do, though, as we note that the states of Colorado and Washington last year in the US, the citizens voted they want to make marijuana legal. We can see down the track, Washington, Colorado, they bid. What are they going to do? We'll see what happens if it still goes through in the US. The federal government may come over the top, but what are they going to do? Are they going to say, no, our code applies and we're not going to listen to what the citizens of these states have said? Who is this body? The other thing, caffeine. Caffeine's a substance that one time was in, one time was out. They're not sure about it now. So what they say, it's being monitored. Think about this, is in terms of what's actually going on. The other issue is in terms of PEDs, as we've heard. All heard about PEDs and the AFL and the NRL and the blackest day in Australian sport. I'm not saying there's not organised crime and those things involved. Of course we're always going to have organised crime. However, the biggest issue about organised crime and what's going on in Europe, it's money laundering. They're the bigger issues. It's not about young athletes playing sport. Yes, there are certain athletes. I'm not saying there are not things going on. But I come from the view, WADA, we've got to remember, is a private organisation. As Catherine was explaining, half the money comes from the IOC, half from governments. I don't know how governments got conned into this, because think about this. It's a private organisation. They've set up a code that none of us have actually had elected representatives, and they've set up this code and they've decided. I reckon if I went round most of you in the room here tonight to explain to me what a PED is, and if you actually read the code and what it sets out, it's very, very loose. I'm conscious of my time, don't worry. Is in terms of The other debate that's going on is unless a player's had scientific training, they would have no idea what's going on. So there's other issues is in terms of and the bill that went through. The other thing I want you to think about, and as Andrew just mentioned about producing documents, doing these sorts of issues, is in terms of, but there's a sting in the tail. If you're found to have lied to ASADA, you will then be charged on the Commonwealth Criminal Code for providing false or misleading information, carrying a 12-month penalty of imprisonment. What are we doing? There are real issues out there. This is sport, is in terms of through. However, fortunately, we have the High Court of Australia. This year, at the same time, just in June, 3 days before that legislation went through, they handed down a judgment called X7 of the Australian Crime Commission. And they said, the Australian Crime Commission Act does not authorise an examiner appointed under the Act to require a person charged with a Commonwealth indictable offence to answer questions about the subject matter of a charged offence. Thank heavens for the High Court. But does this mean we're going to have athletes with deep pockets and the time to be able to get there? A couple of points as I conclude, Deb, is in terms of what about the many participants who were under 18 years of age? What are going to be their protections? And you may think, some of you may remember, it was only a few years ago, they turned up at a schoolboys rowing regatta and wanted urine samples from people under 18 years of age. Think about this. Second is in terms of targeting not just players and officials, they want associated staff, registered medical practitioners. Happen to any right to privacy? And it's in terms of the bureaucrats. I mean, this is a bureaucracy that is happening before our eyes. But the Public Authorities Oceania representatives on the 38-member board includes the Australian Minister for Sport. At the time when this legislation was pushed through, and I checked, and it may have been nice, I may have missed it, but I never saw in Hansard any mention of her role. At the time, wasn't this a conflict of interest when you're pushing through legislation for a private organisation of which you sit on? I'm at a loss to understand how the federal government got involved in this, other than in terms of the UNESCO code that came through at the same time. But UNESCO, as you know, we think about education, health, other issues, and that's how the sport got in. Things to think about. But fear not, next month, the World Conference on Doping and Sport in Johannesburg, 12th to 15th of November. Fantastic. See the travel entitlements. I mean, I wonder who's going to pay our sports minister. Seeing entitlements have just been in the news of late, who's going to pay? WADA, the minister personally, or us, the Australian taxpayer? Also is in terms of who's going to decide what's performance enhancing. I still like, and I know he's considered a pariah by some, but the first really great sports doctor we had in this country was Dr. Tony Miller. He's still alive, he's 87. I actually spoke to him last night. I said, Tony, how do you feel? He said, he was the Commonwealth Games doctor till 1986 and he was considered, get out of here, you harlot, get out. Because he actually said, it's rubbish, it's all rubbish. And he went on to say, I've administered 5,000 clients over the years. No one grew a third testicle, no one got cancer, no one got any heart problems. There are issues. I'm not saying there aren't, but he said, probably medically supervised, it raises bigger issues. And as he said to me, what about injections? Half-time in any big football game, everyone knows the injection happens at half-time. What about if I get a knee replacement? Isn't that performance enhancing? Shouldn't it, in an era gone by, be the end of my career? Where do all these things go? In the end, where do we finish? The Minister, as she passed this legislation, said, yes, it'll be $5,000 penalty, and that's what we're going to do. And she finished off her website with share and enjoy. You know, that's share and enjoy. I don't know if it's going to share and enjoy all those people in sport. I'm more of the view of Oscar Wilde, who said, life's far too important to take seriously. And in that, the words of John Mortimer, with his wonderful Horace Rumpole, and I'm going to conclude with share and enjoy this. And he said, when London is nothing more than a memory, and the Old Bailey has sunk back into the primeval mud, my country will be remembered for three things. First, the British breakfast. Second, the Oxford Book of English verse. And third, the presumption of innocence. That is the golden thread which runs through the whole history of our criminal law, so that no person shall be convicted if there is a reasonable doubt as to their guilt. Thank you for listening.
The only thing I can say about that is we need 5,000 of you spread all around the world to give that exact message, because the athletes are at such a rotten end of this whole process. It's so difficult for them. They do sign their lives away. They're not allowed to talk. They're not even allowed to tweet on anything that might resemble a certain type of opinion, which means that the only people giving stories to the media are these people in authority who have hidden agendas. And as you say, some of the people that serve on this court of arbitration for sport, which is not a court at all, have so many conflicts of interests. It's ridiculous. Okay, let's move on. Our next speaker, a late inclusion, but a very happy one, from the Private Law Research and Policy Group here, Professor Prue.
Well, thank you. I should say that I did get called in quite recently, but I'm very happy to be here, and the more I looked at this, the more interesting I found it. I'm going to talk about, we're going to change direction a bit here, and I'm going to talk a little bit, I'm going to talk about tortious liability for doping, and which means that to some extent I'm going to move away from the emphasis on the WADA code and be talking more about doping in sport generally rather than that regulatory activity itself. So just consider a couple of things. Despite the fact that Tom just said nobody gets heart attacks from performance-enhancing drugs, a US football player is currently suing his former team and a pharmaceutical company that is associated with his former team, and he alleged they gave him pain-killing injections that led to a heart attack. That jeopardised his potential NFL career. So that's one story. Another story is closer to home. It's about the Cronulla fullback, Isaac Gordon, who woke up one morning with a black leg, having been corked the day before in a football match. He had this bizarre bruising, and shortly after that, and apparently consequentially, the sports scientist involved was dismissed from the club. Now, I don't know the details of this, but the suspicion is that there was some kind of drug that was given to him that caused him to bleed more than would normally be the case, and that's why he had this bizarre reaction to being corked. Now, as a tort lawyer, if I hear a story like that, I would be asking some questions. I would be saying, well, who gave this to him? Was that person a person who knew what they were doing? Was that a person who was a professional of some kind? Were they employed by the club? Were they aware of the risks of the drug that they were using? Was the drug experimental, or was it certified for the use by humans? Was it known to have particular side effects? Did Gordon consent? Did he consent to an injection? Did he consent to an injection of a particular kind? Was he warned of any risk? When he was warned of that risk, if he was he given a contradictory instruction along with it, such as, well, there's some risk if you take this sort of thing, but you know, there's a risk in everything, so don't worry about it. Now, what did his club know? That is, his employers know about what was going on here. So these are some of the problems that one, as a tort lawyer, might think about this kind of story being told. Now, most of us are aware that any kind of drug has side effects, or may have side effects, and that performance-enhancing drugs may well have cause problems. We don't know about all of them. Side effects of drugs are always an issue. So, for example, if you consider the 1960s and 70s, many children were given growth hormone, and later developed Creutzfeldt-Jakob syndrome, some 30 years later. If you think about, which is actually a close relative of mad cow disease, or BSE, that was a therapeutic drug given which had a dramatic and very, very dangerous outcome. Nobody knew about it at the time, but these may be some of the concerns. The Australian Crime Commission report into doping, organised crime and drugs in sport, says that one of the problems is that many of the drugs come on the black market. They haven't been tested. They may not have been approved for use by humans. Some of them are experimental. And they appear to be administered at many levels. So at this point, what seems to be very significant is the widespread use of certain performance-enhancing drugs of various kinds, including at the Olympic level amongst professionals, but also at the non-elite level and in all sorts of team sports, bodybuilding, all that sort of thing, which may not have anything to do with competitive team sports. They may cause harm to an athlete at the time or later. And in this paper, I'm a little bit more interested in later, because most of the stuff we've been talking about so far has been the relatively immediate consequences of doping, whether it's testing leading to somebody losing their time losing the ability to compete later because of that, or immediate physical injury. But one of the questions is what about the things that happen later because of, and these could be because of the indiscriminate use of something that is simply a painkiller that is authorised for human use but is over-administered and then makes people get more injury while they're at, go back on the field too early and therefore develop more and more injury. So the relevant law here is obviously the law of torts, particularly negligence, and I'm mostly going to talk about negligence. And as most of you will know, when you want to establish negligence, you need to establish there's a duty of care, and the big question usually is whether or not that duty has been breached by the defendant. Now, the legal system, as it operates in Australia at the moment, and in relation to the question of whether a plaintiff has been injured by some form of doping, needs to be divided really strongly between those who are professionals and those who are amateurs, because actually the legal regimes are really quite different in relation to those people. And one thing to really keep in mind is the fact that something's a breach of a wider code. Well, we've already been talking about the fact that it's not law, it's essentially a contractual arrangement. The fact that there's a breach of a wider code does not necessarily mean that prescribing or doing it is negligence of itself. It might contribute to that idea, but it's certainly not going to be determinative. So just keep that in mind as we go along. Now, when you're talking about people who are amateurs, we have a whole series of recreational activities regimes in Australia, in most of the jurisdictions apart from the Victoria and the Northern Territory. And that makes it very hard for somebody to sue a recreation provider where they've given some kind of risk warning. However, the protection from the risk warning generally doesn't extend to professionals. So where professionals are actually giving advice or about using drugs or injections and so on, these recreational activity regimes won't apply and the ordinary principles of negligence will. However, we also have some other things. For example, there's no duty to warn of an obvious risk in most of the jurisdictions, and in lots of jurisdictions a plaintiff is presumed to be aware of an obvious risk. Now, what's an obvious risk? Is being injected with something where you know that it perhaps is experimental. Is that an obvious risk? That wouldn't necessarily sound in damages. These are questions that we don't know because we haven't seen any, I don't think, of these cases, perhaps these ones that are coming up in the US, and perhaps the case I've been talking about in the Cronulla case might eventually result in something like that. It's also possible to expressly contract out of liability where what you're talking about is recreational services. Now, the Trade Practices Act, currently the Australian Consumer Law, has been specifically amended to make that possible. So again, if something is regarded as recreational, that is being done for fun, and it's defined very broadly, then it's relatively difficult for anybody to get compensation in relation to those things. However, where you have a professional, as I said, they might be liable, and they need to give a warning about the risks, which a reasonable recipient of that warning would regard as significant. Okay, so is that my 30-second warning?
You've got 1 minute.
Okay. So briefly, I'd just like to go on to talk about the fact that there are also issues for where the coach, the trainer and so on is a volunteer. They may well be protected in the situation where we're talking about recreation and therefore in children's sport and things like that. But that protection of volunteers depends on them acting in good faith. And there's a query here about whether you might have a voluntary trainer suggesting to somebody that they take some kind of performance-enhancing drug. Could that be regarded as in good faith? Again, these things haven't been tested, but they're the kinds of questions that we would want to ask. Minors are a very big issue here because many people involved in sub-elite sport and some in elite sports are minors. The 16-year-old Romanian girl is a case in point. There are all sorts of issues in tort law about minors' ability to control, and in Australia in particular, we have reduced the capacity of minors to sue in various respects because of the way we've allowed limitation periods and so on to be reduced in respect of them, and of course the issues about consent. And just going on to I'll just try and take 30 seconds to talk about the professional or the employed athletes, who are mostly the people that we have been talking about. So the general occupational health and safety rules apply, but they don't prevent other forms of civil liability arising. So a professional sports person is generally an employee. They are owed a duty by their employer to provide them with some kind of safe system of work. Okay, nearly all sporting activity involves risks. It's not possible to put people into cotton wool, but there's clearly a duty to look after the health and safety of your employees, and the question about performance-enhancing drugs and the possibility that they may actually, if administered negligently, that is, without knowledge that they are safe, without proper warnings, especially if they have been got by the black market and so on, suggests that there's some very good reason to think that there may be litigation down the track. Just briefly, say a club or as an employer may well also be vicariously liable for the actions of any of their other employees, that is, trainers, doctors employed by them, and so on. And it's fairly difficult to get out of that vicarious liability unless you can establish not only that there's an intentional wrong being done, but that that intentional wrong really has no connection at all to the scope of the work that was supposed to be being carried out. Two small points. What about the plaintiff's conduct in accepting the substance or giving consent? Can that amount to a defence? Well, it's a defence if someone's engaged in an illegal activity, but we've already established that breaching the WADA code is not necessarily an illegal activity. So that probably is not going to operate. It might be a voluntary assumption of risk or at least contributory negligence. That will depend on the amount of knowledge the person has. And as has been said before, most of this is something that scientists are only beginning to understand some of these things, the new peptides, the new hormone, this is new language to me, and I just read this report today, and we're talking about hormone-releasing peptides and new hormone and anabolic steroid markets, etc., etc. All the chemistry and so on associated with that is fairly complex, and I imagine that the average sports person would not really be able to assess for themselves whether or not that was a dangerous thing to be taking. So my conclusion is it seems pretty likely to me that there's a ticking bomb here, that people may well, that clubs, trainers, coaches and other professionals may actually, if they are indiscriminately or fairly laxly prescribing and giving these sorts of doping substances to their athletes may well be finding that they're at the receiving end of litigation at some time, and that will lead to, and that will be considerable damages in things like that, even though our civil liability acts have actually put caps on the amounts of damages. They're still considerable, and most people don't like to have to pay damages. So thanks.
Yeah, that's really interesting points that you raised there, Prue, because I know, like in the Essendon case, for example, there was no OH&S training for any of the coaching staff and whatever, so where does the responsibility lie? Is it with the directors of the club, or is it actually the directors of the AFL that own all of the clubs? And I think in finding, you know, a victim fair way down the food chain is just a very easy out to avoid many of those questions. Okay, finally tonight, she was described in the very beginning of the session as the mastermind behind this evening's session. You're all very familiar with her. Would you please make welcome Deborah Healey?
The regulation of doping in sport really requires a multifaceted consideration of a whole range of issues of a complex nature in both social and legal terms, and for that reason the concept behind this forum was to look at doping in sport and the wider code itself through a number of distinctive legal lenses, and I think that the comments of the previous speakers emphasise some of the complexities of these issues quite clearly for you. And there are many other areas which could have formed part of this consideration. Employment law, which Prue has mentioned, but administrative law, interaction with criminal law, organised crime, relationship with match fixing, and very many others. So my contribution to the forum, however, will be to take a step back and look at a number of issues which I think are important in relation to the doping regulation generally and to the wider code itself. And the forum, as you would all know, but I'll remind you, is also set against the many national and international controversies in the last 12 months involving doping. And I'll just go through a few of them just to heighten your understanding. Again, you know, we had Lance Armstrong, we've currently got Alex Rodriguez. We had 107 athletes banned from competing in London because of their infractions. We got the findings of the Australian Crime Commission report, which are a tad vague but very interesting. And we've got the problems facing the professional football codes in Australia, which have been very well publicised. And those are just a few of the things that have been going on. And I note also that partly because of the popularity of sport, media commentary on all of this is often sensationalist and unhelpful, which is one of the reasons why I wanted to get people who had particular expertise in these areas to turn their attention to doping in sport. And finally, before I make my comments, I would like to say that I'm actually committed to drug-free sport. But like some of my colleagues, I have a number of queries about our current regime. And first, I'd like to look at the basic assumptions of anti-doping regulation. And anti-doping regulation, and particularly the wider code, are based on the idea of a creation of a level playing field for pure competition in sport. And I agree with Tom. Some of the comments made in relation to the Olympic movement about Olympism and fair play do sound a little bit like a religion, and surprisingly they sort of all popped up at a particular point in time. They weren't really discussed in that way until I would assume that the market has got hold of it all. So that's one thing I would like to say. We're talking about, however, in the words of WADA and the IOC, pure competition in sport. I thought I'd play the devil's advocate a little bit here, and when I was preparing for this session, I found an article in the New Yorker by the celebrated author Malcolm Gladwell, who's the author of the books The Tipping Point and The Black Swan, to name a couple of them. And he asks in that article, which is only a few weeks ago, whether it's time to reconsider some of the assumptions which underscore our doping regulation and in the way in which our quest for the level playing field is currently implemented. He said, quote, "Elite sport is a contest among athletes with an uneven set of natural advantages." So while we want sport to be fair and we take elaborate steps to make sure that no competitor has an advantage in terms of use of performance-enhancing drugs, there can never really be a contest amongst true equals due to the physical differences between individuals. And he gives a number of interesting examples in his article about all that, like the, I think it's a Finnish cross-country skier who has so much oxygenated blood in his system that his face is purple. I think he'd won 6 gold medals at the Winter Olympics. And there are a number of other examples of natural advantages of particular races because of particular physiques and where they live, and that's an interesting issue, I think. Physical characteristics are clearly not generally regulated, and nor are many forms of corrective surgery, which are quite prolific in some sports like baseball. You know, they have the replacement of the elbow tendon, and they also have their eyes lasered so that they have better sight. And that's all very interesting, and that article is available on the New Yorker website if you're interested. So really there are already significant logical shortcomings in the basis for the creation of a level playing field in sport, which provide at least some food for thought in discussions about performance enhancement in sport. But no one seems to ever, everyone accepts that this is the way to go. And I think that, you know, stepping back and looking at some of the issues may cause people to have some more queries about it all. Secondly, I'd like to talk about the WADA Code as regulation. Now, there's a lot of discussion and scholarship today about regulation in law. Regulatory theory dictates that the general concept of regulation today is far broader than it used to be, and there is a lot of discussion in legal texts about what makes good regulation. Traditionally, regulation was just law, but today it encompasses governance with control emanating from both public and private actors through laws, private agreements and other control mechanisms. So the WADA Code is really an example of modern regulation. Control emanates from both public and private actors, and it's a cooperative approach to regulation by government and various stakeholders. It's a true attempt to address areas of technical, social and political risk, which are also the focus of modern regulation. It has regular review, it has consultation and transparency of the development processes. And that suggests that optimal regulation might be possible. But all this, I think, is hugely complicated in the sporting context for reasons such as the complexity of the subject matter, the variety of contexts in which it's implemented, and we've talked about the one-size-fits-all approach of the WADA Code, its suitability to the Olympic movement, but whether it's suitable, as Catherine said, to those weekly sports is a query that needs to be thought about. We've got difficulties of detection of use of substances, continual development in pharmacology, which mean that the testers are often one step behind. But we also have the basic motivation of athletes. We have athletes striving for better performances, coupled with the rewards that go to winners. And there is usually only one winner. And so athletes have really substantial incentive to win at all cost. And I think that all of those factors mean that regulation in this area is particularly complex and difficult. So thirdly, I would like to mention a number of specific issues which appear to be problematic in relation to the WADA Code. And that's despite the fact that much time and effort has been put into developing it. Firstly, and it has been alluded to, the complexity of the code means it's difficult for athletes to fully understand its principles of liability and punishment. And I accept that there have been significant efforts in many jurisdictions to educate athletes, but the code provisions are complex so that any level of understanding beyond the superficial is extremely difficult even for the well-educated. And I have been dealing with this code since it started, and if I haven't looked at it for a while, I've got to go back to basics and start again and read through the whole thing and work out where everything is and what it means. It's counterintuitive in a lot of respects for a lawyer, the way it's drafted. In addition, of course, many athletes are so focused on their performances that detailed investigation of code provisions by them is unlikely despite their importance. The prohibited list itself is a particular problem for athletes. It's extremely complex. It contains a very large number of banned substances under their scientific names and general catch-all provisions aimed at other substances with a similar chemical structure or a similar biological effect. Now, the reason for the inclusion of that provision is obvious, because very similar but as yet unlisted products could be developed if the catch-all did not exist. But this makes it very difficult even for athletes who have no intention of doping to understand what's on there. It also means that they're at the mercy of others in relation to what they ingest, even if they have good motives. And you can ask any young man who wants to be a star whether he would take whatever his coach tells him to and see what he says. He'll say how much and how often. One might well say if athletes took nothing, they'd have nothing to worry about. The intricacies of the list would not be a problem. But the inclusion of banned substances in many over-the-counter pharmaceuticals and remedies for minor ailments such as a cold or a rash, as we talked about before, complicates the issue. There have been examples of medals, also athletes losing medals and titles because products marketed under the same name contained different substances in different jurisdictions, and the athlete assumed it was the same as in his home place and just took it. Linked to this are the difficulties of absolute liability for truly inadvertent users, and we talk about Radican. And the new wording is quite specific in the examples which will not constitute no fault or liability. It's very heavy-handed. It's incredibly difficult to get a defence. The fact that your trainer gave it to you and you didn't know doesn't wash it. It makes life very harsh for any athlete relying in good faith on one of these people or on the contents list with on a particular product with no reason to suspect risk. And I make a couple of points in finishing. Catherine's mentioned the complexity of sanctions for teams, and my only additional point to Catherine's on that is, whatever governance methods are employed, my experience with compliance in areas of regulation and law is that with the best will in the world and with sophisticated compliance systems, sports will never be able to make absolutely certain that none of their athletes are doping. Hence, if you have that 2-athlete rule for an AFL club, a soccer team or an NRL club, it will have devastating impact. Lastly, one must ask whether this is an example of regulation imposing ever more onerous obligations on sporting organisations and individuals in circumstances where those who are already complying are overloaded with obligations and those who never intended to comply still don't comply because they believe they won't be caught. 2 more things. Cost, time and resources employed by sports, which they usually don't have. We can see from recent experience how teams involved in 2 of Australia's richest sports appear to have failed in governance or control of their processes to ensure compliance. Most smaller sports do not have the same level of resources, even if they wish to comply. And the last point is the one-size-fits-all approach simply doesn't work. And that's all I'd like to say.
Thanks, Deborah. I've got to say, as a very young journalist back at the ABC in 1989, the first book I ever read on sport and the law was yours. And continues to be a great reference. It's interesting when you talk about the wider code being quite consultative, because I wonder who asked the athletes, and I don't know how they survive in what they're supposed to do week in, week out, more and more demands, the physical strain on the body, and it's very easy from the outside to say there should be drug-free sport, but I wonder how many people in the room here live a drug-free life. And I don't just mean, I don't mean recreational drugs, but I mean if you wake up and you feel sick and you've got a heavy day you've got to get through, do you take something? As an athlete, you can't, but the rest of us can. And I just wonder why athletes have to be a complete subset within our society. It's fascinating. So many questions, but what we want to do is open it up to the floor, because surely you've got questions of the various experts here. You don't often get access to a panel like this. So if you do have a question, please raise your hand while you're thinking about that. And it always takes a while for a bit of courage, that word that you mentioned, to come into a group. I just want to ask you, Catherine, When you mentioned the North Korean team, we know that most people in North Korea are starving. We know there are cultural differences. I wonder, the element that they tested positive to, how much of that is in their natural diet, and how are considerations made for that sort of thing? Because I know, living in China for 7 years, there's many things that you can eat on any street corner that will probably mean that you will test positive should ASADA turn up at your door between 6 a.m. and 11 p.m.
I think that's a very good point, Tracey. Sorry, I'll just lift up the mic. That is a good point, and I don't think it was fully explored by FIFA when they looked at that. FIFA's report that I've seen in this North Korean case is about this long, so detail was not something that we were bombarded by. They did express that there were 19 different steroids in this deer musk, and I'm not entirely clear what deer musk is. I've done a little internet cruise around, and there's all kinds of suggestions that it might be kind of the furry stuff that comes off the horns, or something to do with the male testicles, or some other variation. I don't know, one end or the other. It seems to be fairly...
Is the furry stuff off the horns?
Is it the furry stuff?
And you can buy that anywhere, like on any... I'm not in North Korea, shops aren't, you know, a dime a dozen, but I know in China you can, yeah.
Yeah. So whether that's a legitimate form of treatment for being hit by lightning, I'm not entirely clear. I'm not medically trained, so perhaps that is a legitimate form of treatment. But
it's not even a form of treatment. They boil it up and drink it like tea.
Okay, the medical doctors, what was contained in that report that was this long was that the doctor presented that that's what they used, and so the doctor was also banned, along with the 5 that went positive. And the doctor had said that they'd given it to the entire team. So that to me was an admission, and why the rest of the team wasn't banned, I wasn't entirely clear. And WADA decided not to appeal it for whatever reason. So your question was about the cultural differences, and I don't know that it is always taken into account very well. I know that there were some studies at one point about the kava that was drunk in different parts of Oceania and what impact that might have on athletes. But and then there was also some research in Scandinavia about the tobacco that they use in their inside their mouth, that they just have sitting inside their mouth, whether that might have performance enhancing benefits and so on. But it doesn't impact except when the faceless men of the prohibited list, I can assume the faceless men of the prohibited list, get together and decide what's on and what's off. And in that case, I suspect that it's not a particularly diverse group of people that are deciding what's on the list and what's not. And perhaps not all the various cultural considerations are taken into account.
And I guess it comes back to some of the other points that were made a bit earlier too about, you know, the punishment fitting the crime. And you wonder what happened to those North Koreans. We know just for losing matches in the past, members of the North Korean team have been shot. So bringing great humility on the team by testing positive, you wonder what happened when they got back home. Questions? You've got your courage now? Who's going to ask first? Yep, there we go. Microphone's just behind you.
Hi guys, thanks for a really interesting set of presentations. I'll stick my hand up and say, my name's Jason, I'm from UNSW Canberra, and doping is my life in terms of research. So what you've described collectively can actually be found in the Cycling Australia review. So all the things that have been brought up have been significant problems. From my point of view, it's really easy to lay the boot into the World Anti-Doping Code. I mean, we've got people who looked at it very recently in terms of torts law and found all sorts of problems. In terms of what do we do next, this is my question in terms of policy and where my work is, and I'm really interested to hear what you guys think. If it's so complicated and it's so difficult, what do we do next? Do we throw it out? How do we discipline the bureaucrats so that they don't behave in these perverse ways? What do we do to fix this issue of drugs in sport? To draw on Deb's very important point, most people I speak to about this agree with the idea of some form of drug control in sport. What they don't like is how it's done. So how do we achieve drug control in sport, perhaps not using anti-doping, but using some other method with your various range of expertise?
I think you're all being very polite too, referring to it as the bureaucrats and the bureaucracy, because you can probably also say, you know, the autocrats and some of the dictators that run sport and implement these regimes. So who's got an answer to that question to begin with?
I suppose there are two ways. I mean, when you're looking at how you get people to comply with legislation, I mean, obviously it's a matter of, on one hand, changing the culture, but that's quite difficult because of the points that I made about the incentive to have the best performance, being both financial and also, you know, the prestige and what you want to do as an athlete. So that is very difficult. But I mean, I think that someone might want to do some research on, someone might want to do some research on cultural change in sport. But as to the wider code itself, I think the key to it is, recognising that it's not appropriate to have a one-size-fits-all model. I was surprised at the number of Australian professional sports which wholeheartedly adopted the wider code. I can see why the Olympic movement sports would, and I suppose, you know, if the government is saying, well, you won't be funded unless you do, but I can't see why major professional sports could not have an equally strict but more appropriate regime applying to them. I think the problem with the wider code in some respects is that it's made far more difficult because it tries to be one size fits all. I think it could possibly be simplified if it was not trying to appeal to so many different, or apply to so many different sports. Someone else?
I agree with Deb. It should be simplified. I mean, as I gave the example, talk is in horse racing. We don't have, you know, the international horse racing code and whatever. Each group deals with, within their sport, how they deal with it. And exactly, I mean, if you actually read, as you said, in terms of the code itself, it's mad. As in terms of when someone needs to sit down and say it's mad, and actually, yes, there is a problem, but it's a smaller problem. That's the other issue. How big is this problem? And the thing is, in terms of whether the code should be sitting down and thinking through something else. The reason some of the football did, because of government money, obviously, and where the AFL and the NRL have got involved. But it's not just that, there's lots of others. Yes, for Olympic sport, I understand that, but for a lot of the others, it doesn't fit and should be simplified.
I don't know whether this panel that's mostly made up of lawyers is really the best one to ask, because I think what has happened is that over time the medicos have been taken over by the lawyers in this space, and that means that we've really got one perspective on how to solve this problem. And what we need to be doing is diversifying and bringing in a number of different people from different industries and different professions to try to solve this problem. And I know, Jason, I think you attended the Crime and Sport conference that was up at Griffith Uni recently. It was on just recently, and we were on it together last year. But Stephen Noston was talking about a whole different perspective from a forensic psychology perspective, and looking at how you can identify athletes in advance that might be interested in doping, and then focusing your efforts on those people rather than putting resources across the whole sporting spectrum, including those people that are just going for a run around the park, as you mentioned, Tom. And I think perhaps we need to be doing that, because the way that we use our resources right now is very intensive and certainly not a good use of Australian taxpayer money.
Or of anyone's money. Yep, next question. Yep.
My name is Michael, and I'm another lawyer, and I work for the firm that runs the Court of Arbitration in Sport in Sydney, but I'm not here representing the court. Dr. Hickie asked why the federal government is giving money to the private organisations that set up the WADA and so on. And I think the answer is, in one sentence, public outrage. A public outrage at this behaviour that is fed upon by the media. So the question is, how do we address this public outrage? Following up on your question. Do you think it would be possible or advisable to implement for the domestic codes and the weekly sports, not so much the Olympics and the international sports, but to implement some kind of provisions in Australian legislation or state-based legislation, either into the criminal law or other types of regulation? And then we would attract the due process of the Australian courts and so on. This would have benefits, but also the private organisations that run these sports might be annoyed at this, But it's been done before. You could look, for example, at the Bribery Act in the UK, which has been used to prosecute match fixing. Could this kind of thing work for doping?
I suppose one of the problems with that idea is that currently a lot of the conduct that's going on by athletes isn't actually a breach of the law. And that's why I think, going back to what Professor Byrnes and Dr. Hickie were saying about the new legislation about answering questions about responding to ASADA and assisting ASADA is so different from other forms of legislation on which it's modelled. I mean, it's modelled on provisions in the Crimes Act. It's modelled on provisions in things like the competition law, where you have to answer the regulator. But of course, in most of those cases, it's ultimately about a crime. In this case, it may or may not be about a crime. So I think I would be a little reluctant to introduce criminal liability into conduct which basically is a breach of a contract between a sport and its participant, or an event organiser and its participant. I suspect that what was put into that new law could have been quite easily put in as a clause in those contracts. Didn't need to be put in as a provision of an act. So I don't know if I've answered you, but I think that we need to really be quite clear that a lot of this conduct isn't in breach of the law. Some of it is.
Except perhaps in France and in Italy, where they've approached it quite differently. So that's one of the questions that comes up every 4 years or so, is whether or not doping should be considered a crime across the board in every jurisdiction. Because at the moment we've got the difficulty of some jurisdictions treating it differently to others. And here, of course, it's not a crime unless it comes under the specific provisions of the Customs Act or something or other else, where it's a particular prohibited substance. And there was a push on in the lead up to Sydney that we tried to get everything on the prohibited list included under the Customs prohibited schedule as well, particularly something like EPO, which has legitimate therapeutic use, but only in very limited circumstances. And if you look at the amount that's being manufactured and the amount that's being used in the community, it's massively disproportionate to the amount of therapeutic use out in the community. So there's a big gap somewhere, and that's not being addressed.
Well, what about, I mean, I suppose this comes back to cultural things once more, the EPO. The impact of EPO on cyclists or other such athletes is the same kind of impact, but quicker, that you get from the hyperbaric chambers, which are legal. So, and all of this sort of doesn't really make much sense, and there seems to be, we were talking about the lawyers that run WADA and the code and everything along these lines, being from Australia and Canada, places where you think, you know, human rights are respected, and yet they've got these complete anomalies which support their system and really don't support the system of other cultures. It's that's damning as well, isn't it?
Mr. Graham wants to answer this question. He likes this one. This comes up often. It came up in the grade 5 class that I was interviewed by quite recently.
The comment about the use of EPO versus hypoxic rooms is incorrect. When you inject EPO, you override the body's own self-control regulatory mechanisms that further inhibit the production of EPO. So if you go into a hypoxic room, yes, your kidneys secrete EPO, that produces new red blood cells, but as there's more oxygen available, the production of EPO by the kidneys reduce. When you inject it, you override those safety mechanisms. So the two mechanisms are actually different. And it's the overriding of the safety mechanisms that can put the athlete at risk.
And that's the same then with blood doping, and that's why that's banned and not the chambers. Is that right, Kenneth?
Same reason that you override a lot of the safety mechanisms in the body.
Yeah, because that question comes up very often as well.
Other questions? Yep. Here comes the mic.
Dr. Hickie, if I heard you correctly, suggested that performance-enhancing drugs should be encouraged. At what age should children start taking drugs? How much should they take? And what happens if they break the limit?
Good question. It's in terms of what's going on now. Is that if your son is 16 and he does his leg, surely he's getting performance enhancing, goes to Prince of Wales and gets a replacement taking place. I mean, why are we focusing, I think Tracey's raised a very good point there, is in terms of the whole issue of doping. It is very small, as in terms of we've got to look at doping in context of very other things that are taking place. I was laughing with one of my colleagues who's here tonight, is in terms of, if we're talking about playing fields, surely being born in Sydney, Australia, is unequal playing field. Surely being born on the North Shore, raised on the eastern suburbs as I wasn't on an even playing field, the kids in the western suburbs. I mean, when we're talking about playing fields and equality, we've got to really step back and think, what are we actually doing here? And coming back to the question that was asked, following on from that, I actually think the sports should actually administer themselves. I mean, we allow that to do with violence in sport, we allow them to tribunals, and then if we're not happy, they can appeal to a judge in a court. That's what should be going on. And in terms of, I'm glad we've got a great administrative lawyer here tonight, is in terms of people can review. You actually can, if you're not happy with what happened, you can get natural justice. You can look at various things. And as in terms of with this, I think in terms of with kids, sure, you're going to look at, but are we going to turn up at rowing regattas and get 16-year-old boys to start peeing in jars? I mean, what are we doing? Aren't we trying to just encourage them? We've got enough problems with mental health as we know in this country. So I think there's things we've got to think about. Take your point, these are complex. They're not simple answers to it. Okay?
Talking about Prince of Wales for an operation, that's performance restoration, that's not performance enhancing.
Oh, no, it is enhancing. Surely it is. Is in terms of with that. It should be the end of your career. In an era gone by, that's it. Is in terms of now, of course it's performance enhancing. It's not restoration. Enhancing. Disagree with you, but
I think the other issue is one of trust. Actually, that's what it boils down to in the anti-doping space. Australians, of course, are pristine and we're all fabulously clean. And it's the other countries that we really can't trust. So we need to have these rules out there because who knows what the Russians are doing and those Chinese, sorry, Trace, the swimmers, we can't trust anybody else. So we wouldn't allow them to administer it themselves because we wouldn't be able to see that there was transparency and that there was accountability unless we could get our fingers in that pie. So that's why we put the President as an Australian. Obviously, we wanted to control the entire world of anti-doping. And that's not going to be enough after he finishes up in November when we've got the new President coming in. I'm not quite sure how we're going to handle that.
More questions from the floor? Yep, over here.
Hello. My question is just if Andrew or Prue, if you guys had any further comments on consent, which you both touched on briefly, just with regards to like a discipline like rugby league where as a professional athlete you give yourself over entirely to your nutritionist, to your trainer, you put your own safety in the hands of those people, the amount you can see your family is restricted, everything is contractually outlined, just from a human rights and or torts perspective, how that would tie in a bit further is interesting. Thank you.
Well, from a human rights perspective, I guess the issue is have you consented or have you waived relevant rights within the process of regulating in the sport is one issue, so the procedural rights. The other is have you waived any rights in relation to the treatment, which I think overlaps with the tort and employment law issue. And I think the answer must be no. I mean, that consent is, in human rights terms, a rather empty one because of the notion. But it comes back in various categories. As voluntary participation, yes, it's voluntary at one level, but once you enter it, there's not a lot of voluntariness, and the power relationship is very clear.
I guess I think the consent that we're talking about for many of these people is just like the consent that you have when the Electricity Commission gives you a contract. You know, you actually don't get very much choice. It's either you're in or you're out. And so consent is often fairly meaningless in that kind of context. And if it isn't that kind of context, then it's the situation of the 16-year-old who says, you know, as Deborah was saying, if the coach tells me to do this, I'll do it. When do you want me to do it, etc., etc. One of the things, but I think that's one of the reasons why looking at the employment situation is interesting, because an employer generally is regarded as having a non-delegable duty to do something about safe, a safe system of work, whatever that means in this context. Presumably, giving people substances that without thinking about where they came from, especially if you may not know their provenance and so on, is clearly something that a club or whatever should and would be held responsible for. I think this is actually about harm to the individual and the normal professional responsibilities of people like doctors in clubs and things like that. And there it's pretty simple. A doctor who is prescribing in a lax way or using black market stuff is clearly the kind of person who should be struck off and certainly would be regarded as negligent. One thing that occurs to me about this is that, I think of rugby league and all of that as essentially entertainment. And it's actually the money behind the business and so on that drives a great deal of this. And I wonder if there are one of the reasons I'm interested in damages is because any club that's working out its future budgetary arrangements is going to be thinking, the possibility of paying damages might wake them up in the way that something else would. But also, so will certainly the prospect of having somebody knocked out of a competition for a long time is going to have an impact as well.
I just wanted to add something to that because Prue's been talking about negligence, but a lot of these organisations and individuals are insured for negligence, but their negligence insurance would not cover some of them for the sorts of activities that they're undertaking because a lot of it is intentional, it's not negligent. So that's another issue which may be thrown into the damages mix in all of this.
And in fact, for some of those, it would take them outside the Civil Liability Act, which means more damages.
How damaging can it get? I mean, if someone in a workplace is killed through some sort of accident, it's a couple of $100,000 fine. There's
it might be a fine, but at common law, death was not something that could be complained of.
No.
It's always generally
I'm
better
not saying that, but when you put it in perspective into a sporting term, where they say lifetime ban from the sport because someone tested positive to a drug that is not illegal. It just seems so out of whack, and I wonder if there's a bit of a sort of moral panic involved in the whole drugs in sport discussion and whether we need to get right back to basics before we start again.
On one of these issues, I mean, we know about contracts, and Deb, in terms of with competition law, would argue some of these issues through that. Players, like the wonderful Dennis Tuddy case, we used to have that players had to play for certain clubs, retain and transfer lists, the George Eastman case. Wonderful things that people, yes, coming back to your question there about these things, players signed these contracts and the court said invalid. Right? It's in terms of, so there will be, I actually think there will be eventually, where someone has lost their livelihood over a few, is going to go to court. And a court, hopefully, we get up to the High Court, who will say outrageous, as they did in the Dennis Tuddy case. And it took all the way for Dennis Tuddy to go all the way to the High Court and sit out a season from Balmain in rugby league to actually say, this is rubbish. And that was a system that had been in place for 70 years. So.
From the floor, more questions? It's about 10 to 8. We've only got about 10 minutes left anyway, so you should get in quickly because you're not going to access these people again. We've got a few. Yeah, we'll start here.
Sort of completely tangentially, I was thinking of the laws about prostitution, and everyone goes for the client and not the person who pays. which is really peculiar. And here we've got FIFA, or FIFA, however you pronounce that, and the Lords of the Rings, who are the most corrupt people out of jail, and they're telling us hypocritically to behave ourselves. It's absolutely absurd. The other thing that I like that Tom said is, why are we focusing on drugs and the notion that that brings organised crime, that drugs, you know, I don't know, guns do too, I suppose. Will we now lead into more moral panic and widen the bikie laws? So we'll now crack down on clubs that, or people that wear the Essendon stripe. It's absolutely and utterly absurd. As for your point, I'm sorry, I don't know your name directly in front of me. I don't think that you need to have a crime to have a judge. You don't have to criminalise, as I understand Tracey is saying has been done in some countries. You don't have to criminalise in Australia in order to get the due process and criminal law protections that a judicial system would give you. So I think that your suggestion is well worth exploring along Tom's lines, really. The Code's doing it, first of all, with a decent court second look and an appropriate look as far as the appropriateness of penalty goes.
And it is FIFA, that is how you say it. Yeah.
That's a comment, I guess.
It was a comment. We'll take that as a comment. A very good one. There was a question over the back. Yep.
Hi. Just a quick question. With all the media attention regarding Lance Armstrong and cases that have attracted such high-profile athletes and bringing their issues to the forefront, how do you move from a strict liability framework and then try and step back and say, well, you know, maybe this isn't the appropriate framework to be using to try these people, which to the general public and to a lot of people might come across as taking a step backwards in this sort of situation?
A lot of the sports are talking about these truth and reconciliation commissions, but I don't think any sport would ever let that happen, because it would become obvious fairly quickly that the sports knew exactly what was going on and was doing nothing about it, not to mention sponsors, etc. There's a couple of really interesting legal twists to the Lance Armstrong case at the moment, where he has counter-argued and said that, hang on, you know, the Postal Service is suing me to get all its money back, but you knew exactly what was going on. And on top of that, you've got a whole lot of other athletes that were given 6-month penalties and are back riding, who were doing exactly the same thing as Lance Armstrong, but it was all designed to get him. So it's really quite vicious in its application quite often. Did you have something else to add to that, Prue?
Well, what occurs to me about this is that it does seem like a moral panic, and it reminds me of the war on drugs that we have already seen fail. It seems to me that this kind of approach we've seen again and again and again fail. So maybe it really does need a step back. And although the public might see it as a step back, the public quite often, you know, has to accept that something that was tried didn't work and it's time to do something else. I think the really interesting thing is, when are we going to make sure that everybody is the same height and the same, and that their torso length is the same relationship to their, you know, leg length and so on? Because at the moment we're kind of acting as if, you know, we're working with something that, on the basis that we will get an equal playing field, and that's never ever going to happen until we do that sort of thing.
That's all that what Olympism is built on, you know, all of these shallow terms that no one ever really questions and says, what does any of this mean? Exactly.
I mean, the only other thing we can do, I bet, two things, quick points. Justice Brennan, in his wonderful judgment in Hay Corte, said, oh, the fear of unmeritorious acquittals, we shouldn't worry too much. That's why we'll have strict, not absolute liability. On the second thing is in terms of, we have the stall gift here in Australia. If they want to do that, we can start at the back marker. So is in terms of Bolt, he can start on the back and someone else forward if they really want to do that in the Olympics, or in the Melbourne Cup. Farlap had to carry 9 stone 10 and still win, you know, if that's what they want to do. But of course, I agree with Prue, there is no level playing field. It's a nonsense.
I was told once by one of the doctors from an unnamed African country, he said to me, you people in the Western world, you have your doctors, your psychologists, your nutritionists, you have your shoes, you have your tracks, you have your simulated surfaces. We have our steroids.
Actually, they have our steroids too. It's the same ones.
That's the level playing field.
And that comes back to, did everyone see Ben Johnson that was out here recently with his program? And I was just amazed that every single time a story was done about him or he was interviewed in the media, he was described first and foremost as disgraced athlete. And I thought, how long can you be a disgraced athlete for? You know, it's a quarter of a century later. And 6 of the other 8 people that were in that race have also been caught for drugs, but none of them are described that way. You know, it just seems so obvious in so many instances that victims are chosen and everyone else gets away with it pretty much.
One of the things that really disturbs me is that some of the things are about things that everybody uses all the time. And asking people to not do that just seems so unreasonable. It's so unreasonable. We've got 3 children. Our 16-year-old is on the verge of becoming a professional rugby league player. And it's an unreasonable life with unreasonable expectations, a heck of a lot of commitment, and very few rights. He signs away his life, effectively, yeah. All right, is there one last question? Yep, usually there is. Mike's coming.
I have a question for Deborah. You brought up the Malcolm Gladwell article, which I think is a very good argument for deregulation. Don't you think the Tour de France would be great fun to watch if they were all on drugs?
They are.
Aren't they?
But like more drugs.
But the problem is, of course, you know, I've had arguments about this with people for years, and you can imagine in various countries and possibly even in Australia where children would be routinely injected daily to give them the best chance of winning more medals at particular, you know, their parents probably wouldn't even know, they wouldn't know, and they'd be subjected to all sort of risk. So I think that's the only thing, you know, people have said for years open slather. That's the only thing I see as the downside of open slather. So, 14-year-old gymnasts, yeah.
I wonder if open slather, though, is exaggerating it. Like, open slather is the other extreme, but surely in the middle somewhere there's, you know, medicine exists, science exists, and there are people who are qualified to administer that.
The problem is we can't trust a lot of them. If you could trust the doctors, you know, this is not a slur on all doctors, but it's the case law and the things that you see give you every indication that there are a whole range of people who are supposed to be helping athletes who are prepared to give them more help than they actually have requested, and or maybe they have requested that help. But you know, the problem is that people will always find a way around rules, and I don't know that anyone can really be.
No, that's true, and I don't know if it's any different to any other sector of society. There'll always be the 3% or whatever it is that commit crimes or that bash women or whatever else. There's always going to be that, isn't there? But I think
the financial incentives here are far greater than bashing women. You know what I mean? No, and I don't mean to be flippant about that, but you know, success, winning is success. Facilitating winning means you're both successful, and I think that the money. You know, you think about corporate crime, how is it different from corporate crime? More people are interested in it, I think. You know, culturally it's important. I've been trying to analyse what the differences might be, which make doping in sport more attractive than committing other infractions. I think there are significant incentives, which I sort of tried to explain but probably didn't do well enough. I haven't really clarified that yet.
Okay, so it's a big and complicated issue, and we hope you can all contribute to it in whatever you do. Could you please thank our very valuable panel?
Before we finish, could we all also thank Tracey for moderating? I thank my colleagues who've participated so graciously, but also thank Tracey for moderating this evening.